In 1973, Congress passed the Endangered Species Act. One provision required federal government agencies to consult with the Secretary of the Interior or Commerce before doing anything that might harm an endangered or threatened species. The act also contained a citizen suit provision authorizing anyone to sue and obtain an injunction against anyone, including government actors, to stop them from violating the act. The Secretaries of Commerce and the Interior issued a joint regulation in 1978 saying that the Act's consultation requirement applied to actions taken by the federal government anywhere in the world. However, by 1986, the Secretaries had limited the geographic scope of the consultation requirement. Thus, federal agencies only needed to consult about potential harm to endangered species posed by projects within U.S. borders or on the high seas. In the late 1970s and 80s, the United States contributed funding to several overseas hydroelectricity projects. Environmental and public interest organizations believed the act required the government to consult with the Secretary of the Interior or Commerce before taking those actions, because the projects might jeopardize endangered or threatened species. The Defenders of Wildlife and other public interest groups sued the Secretary of the Interior, Manuel Lujan Jr., under the Act's citizen suit provision, seeking 1. A declaration that the original interpretation of the Act's geographic scope was correct, and 2. Seeking an injunction against Lujan. The plaintiffs argued they were injured because the government's lack of consultation about the environmental impact of its activities abroad would increase the rate of extinction of endangered species. The plaintiffs argued that the loss of a species impacts the whole ecosystem, and anyone with an interest in studying or working with those animals would be harmed. Secretary Lujan sought dismissal on the grounds that the plaintiffs lacked standing. The district court granted the motion. The Court of Appeals reversed and remanded. This time, the trial court granted the plaintiff's summary judgment motion and issued the injunction. The Court of Appeals affirmed, and the Supreme Court granted certiorari. Justice Scalia, writing for the majority, reversed. The court held that a plaintiff cannot claim standing in a suit against the government if he has suffered no personal injury other than the harm suffered by all citizens. The 3 elements of standing which the plaintiff must prove are 1. An injury in fact, meaning a concrete, actual, or imminent harm to a legally protected interest. 2. A causal connection between the injury and the defendant's conduct. And 3. A probability that a favorable verdict will redress the harm. The court concluded there was no such injury because threats to endangered species were not imminent injuries to the plaintiffs. The court threw out as too speculative the plaintiffs' theories about loss of opportunity to study or work with the endangered animals. Further, the majority concluded that the plaintiffs hadn't shown that a favorable verdict would redress their alleged injury. The court also noted the separation of powers problems with recognizing an injury suffered by private citizens that could be asserted in court based on a failure of the executive branch to follow statutory procedures. Congress would effectively be transferring to the courts the executive's most important power. Justice Stevens concurred that the plaintiff's claim should be dismissed. However, he reasoned that Congress never intended for the act to apply to federal government activities abroad. Stevens rejected his colleague's conclusion that the plaintiffs failed to show an imminent and redressable injury. Justice Kennedy also concurred, finding that plaintiffs did not articulate a sufficient showing to establish standing, but indicating that a similar theory might support standing under different circumstances. Kennedy even suggested that if the plaintiffs had already bought plane tickets to one of the affected places, or set a date to return, it would have been enough to satisfy the requirement. Additionally, Kennedy wrote that Congress has the power to create and define a redressable injury, but it must relate the injury to a specific class of persons who are entitled to bring suit. Here, the citizen suit provision was not intended to allow any person to bring any violation. Rather, the person must demonstrate that he or she has been injured in a concrete and personal way. Justice Blackmun dissented, finding genuine issues of fact existed as to injury and redressability that should have prevented the grant of summary judgment. Blackmun thought that there could be procedural injuries. In other words, Congress could use a citizen suit provision like the one in the Act to confer a right on any citizen to have statutory procedures followed, and the failure of the government to follow the required procedures would cause a procedural harm great enough to create standing. Blackmun argued that the majority's rejection of this possibility could interfere with the balance of power among Congress, the executive branch, and the courts. The Lujan case is perhaps the most important modern case on citizen standing. Lujan greatly limited the ability of plaintiffs to bring suit against the government for generalized grievances. This case represents, in some ways, a limit on the ability of Congress to create judicially enforceable rights through citizen suit provisions, which had been viewed by activists and legislators alike as one of the key tools available to Congress for the enforcement of environmental legislation. While it's easy to find a concrete personal injury if someone has illegally dumped toxic sludge into the plaintiff's backyard, this case illustrates that some types of environmental harms, like the loss of an endangered species, do not uniquely impact a particular plaintiff. As the saying goes, in such cases, an injury to all is an injury to none. If you found this video helpful, you can explore all of our content by visiting us at Quimbee.com. If you have a question or comment about this case, please post it in the comments area below, and we'll do our best to get back to you. If you think we did a good job with this video, please like, share, and favorite it. And if you think this video might be helpful to people you know, please share on social media, Facebook, Twitter, and Google+ as well, to get this video out there. If you haven't done so already and you enjoy watching videos on this channel, click on the red subscribe button just below this video so you can get all the latest updates.